back onto the court.
No.
One hand you are saying that it is for the court we are not being able to proceed with the
No. That is not, my lord, my submission. My submission is, my lord, that your lordships have been pleased to deliver a judgment.
Yes.
Right now, my lord, we have challenged it.
Very good.
Now,
there is no stay.
There is no stay.
Very good.
Now, my lord, in the absence of stay, my lord, we couldn't have, my lord, redone the process because there is no stay. But, my lord, at the same time, my lord, because of situation, my lord, the reservation policy, whatever it is, amended before, after, my lord, has to be given effect to, or, my lord, taken forward because of very many reasons. What are the reasons? One is, my lord, admissions cannot wait. Number two is, my lord,
we are not asking you.
May I say this? May I say this?
No, why the state is so reluctant? They are saying that no. Even if you have said 66 OBCs are there, we will not do that. We will sit tight. We will conduct the inquiry. Bring more than 500 classes again entry. This is not a.
No, these are not in all.
What tussle, Mr. Dotto?
May I say this?
Yourself has appeared and said before us that don't worry, we are initiating the process. You are in CC of the matter. Let us come back with what are the developments.
Please, my lord, do not consider it from that angle. My problem is, my lord, the matter is before the Supreme Court.
Mr. Dotto, why you are not willing to proceed with the appointment procedures and admission on the basis of what remains after our judgment, which has not been stayed by the Supreme
Court? My lord, your lordships have been pleased to, my lord, formulate a process.
Do it for this year, next year.
That, my lord, we have done. Our case is that we have scrupulously followed the order or the process that your lordships have been pleased to lay down, though, my lord, it is before the Supreme Court, whatever it is.
Then we have a right to scrutinize such action on your.
Yes. Yes.
Give effect to this executive order, still we hear the matter.
Just for a period of. Could I say this? My giving effect or not giving effect, please consider this, my lord. Whatever your lordships direct has to be followed.
No, we are at a loss to understand that why state is so reluctant. State says that no, we will not comply with your direction. We will bring.
But my case is, we will demonstrate that we have complied.
You will demonstrate.
Yes.
Till such demonstration, you don't give effect to this executive.
But what happens to my admissions?
What happens? 66.
Now, my lord, please consider, my lord.
6 classes.
My lord, I can understand, my lord, your lordships are taking suo motu cognizance. That is one thing. But
no.
Yes.
Suo motu. We are acting on the undertaking which you have given before us. You have said that, see, our order has not been stayed. We have not jumped upon you. We have given you liberty that, all right, Mr. Dotto, when you are somebody, come with this. Today, when the picture scenario is clear that 66 is untouched by our judgment, you continue the selection process.
And in the event, you decide that these classes that you have selected now are upheld by us or the Supreme Court or whatever, you can hold a special recruitment drive for these persons. There are always these drives that are done on a regular basis in across the country.
May I say this, my lord? Please,
and insofar as the admissions are concerned, there is a single judge decision which says you follow the 66 process, 60 classes then, and you also follow the roster that was applicable then. This is only pending the finalization of these proceedings. In the meantime, you have waited for such a long time. You can't wait for 2 more weeks, Mr. Dotto.
Please consider this. This is not, my lord, what has been passed by the single judgment that Supremo Mondo. But Supremo Mondo, my lord, is only confined to, my lord, joint entrance examination for 2024-25.
Now, for which reason we are saying, for the time being, there is an urgent need for recruitment in the state. In general, we understand that. More so, we understand the district judiciary. There has been no appointment or recruitment in the district judiciary since 2004. There are people who are retiring every day. Our functioning of our district judiciary is seriously prejudiced and affected. So we need urgent recruitment. As a stopgap measure for the time being, the model that has been suggested by the single bench in that Supreme Mandal or whatever it is, the case, you please follow, give us a breathing space so that everybody can bring their stand on record by affidavit. You respond to their application. They will respond to your affidavit in opposition.
Madam, we have not yet used. The state has not yet used. Madam.
No, there was no direction.
There was no direction.
Yes, Mr. Chakravarti.
I have got 3 things to submit. Firstly, my lord, your loss.
Just.
Now the Supreme Court did not grant a stay. Supreme Court on a subsequent event allowed benchmark survey. And that being agreed, public interest litigations anew were filed. Then in the public interest litigation,
Benchmark survey was permitted by the Supreme Court.
on subsequent questioning, they have submitted.
Supreme Court has not said.
Now, more writ petitions which are filed anew, challenging the process of benchmark survey. There your lordships have been pleased to give a limited right to the OBC Commission and not to take any final decision. That is not being pressed by anyone of the
No. That rider is not.
Para 17 of the last order. 6/5/20.